5 seconds to go. Start. Article 81 deals with the composition of the House of the People, semicolon. Article 82 deals with the readjustment and allocation of seats of the House of Parliament after the census, and Article 170 deals with the legislatures of the states. Stop. None of these provisions deal with the legislature of any union territory. Stop. Article 330 deals with the reservation of seats for scheduled castes and scheduled tribes in the House of the People. Stop. Article 332 deals with the reservation of seats for scheduled castes and scheduled tribes in the legislative assemblies of the states. Stop. Both these provisions do not deal with the reservation of seats for the House of Legislature of Union Territories. Stop. In any case, even assuming that Article 332 can be applied to the reservation of seats for scheduled castes and scheduled tribes in the legislatures of Union Territories, it is not shown how the act of increasing the total number of seats in the legislature will offend Article 332, so long as the reservation is maintained as per the formula provided under Article 332. Stop. Para. Another argument sought to be made is that the provision made for 114 seats in the legislature of the newly constituted Union Territory of J&K is illegal. Stop. This submission calls for no consideration as there is no challenge to the validity of subsection 1 of section 60 of the J&K Reorganization Act. Stop. Para. Another argument was canvassed that the delimitation order of 2008 published by the Election Commission cannot be deviated from. Stop. The perusal of the said order shows that it reproduces the delimitation of the parliamentary and legislative assembly constituencies made by the delimitation of parliamentary and assembly constituencies orders of 1976 and 1995 for the state of Jammu and Kashmir. Stop. Both the orders of 1976 and 1995 have been expressly modified by the J&K Reorganization Act by virtue of sections 11.4 and 14.5 as provided in the second and third schedules thereto. Stop. Hence, the argument deserves to be rejected. Stop. Para. The petitioners have overlooked the fact that clause B of subsection 1 of section 62 of the J&K Reorganization Act has further amended the Delimitation Act, 2002 by providing that words and figures census held in the year 2001 appearing in the Delimitation Act shall be construed as census held in the year 2011. Stop. To its application to the Union Territory of J&K, the year 2001 in subsection 1 of section 9 of the Delimitation Act, 2002 has been substituted by the year 2011 and therefore, distribution of seats in the House of the People and seats assigned to the Legislative Assembly will have to be readjusted on the basis of 2011 census, and the delimitation will have to be carried out on the basis of the figures of the census held in the year 2011. Stop. The effect of section 63 is that once the exercise of readjustment oblique delimitation is made on the basis of 2011 census figures, the same will be frozen till the relevant figures of the first census taken after 2026 are available. Stop. Therefore, the exercise of delimitation oblique readjustment of the seats in the Union Territory of J&K was required to be made by the Delimitation Commission on the basis of the figures of the 2011 census. Stop. In view of section 63, further readjustment can be carried out only after the publication of figures from the census held after the year 2026. Stop.